Judge Cameron, it does look like we are a few minutes early, but we do have attorneys for both sides that are present, and I can bring them in if you're ready.
Yeah, I'm ready. Thank you.
And also, just so the attorneys are aware, because I know they can't see the list, we do have Mark Hunter III and Shannon Edwards. So whenever you guys and the judge need them, I can bring them in.
Terrific. Thank you. Well, good morning, everyone.
Good morning, Your Honor.
Morning, Judge.
Morning.
Good morning. I just want to confirm before we begin, we have the court reporter present. Yes, there you go, Ms. Roberts. Good morning.
Morning, Judge. Judge, is your first name, I'm guessing, Thomas?
Yes. First name Thomas, last name is Cameron.
Okay. John, would you pronounce your last name for me? Fadinsky, is that right?
That's correct, John Fadinsky.
All right. Well, why don't we begin? Good morning, everyone. I'd like to call the case.
Okay. All right. Go ahead.
Why don't we begin? I'm going to call the case of Court of Claims case 20-000234, Edwards et al. Versus State of Michigan and Michigan State Police. Appearances, please.
Yes, good morning, Your Honor. Thank you for having us today. My name is James Harrington. I'm appearing on behalf of all plaintiffs in the case.
Morning, Judge. Assistant Attorney General John Fadinsky. Also with me is my colleague, Assistant Attorney General Adam DeBaer, and we are appearing on behalf of defendants.
Attorney Les Braverman on behalf of the minors.
All right. Thank you all. Before the court today is plaintiff's unopposed amended motion to approve a settlement to minor plaintiff Lily Edwards, as well as to distribution to the estate of Truist Edwards, deceased. The purpose of this hearing under the wrongful death statute is to ensure that all interested parties have been properly notified and have provided their necessary consent. They have also waived their right to be heard, and if the court is satisfied that the requirement of the wrongful death statute has been satisfied, I will approve a proposed distribution if I find that it is in fair and equitable under the wrongful death statute. I'm going to turn it over in a moment to Mr. Harrington, but before I do, it may be worthwhile to do a brief summary of the case, and if anyone disagrees with my representations, feel free to jump in after I do so. In November of 2020, plaintiff filed a verified complaint alleging that Rashid Cromier, that's C-O-R-M-I-E-R, first name is R-A-S-H-A-A-D, was active in the scope or acting in the scope of his employment as a Michigan State Police employee when he made an unsafe maneuver in defendant's police cruiser, struck the vehicle in which the plaintiffs were sitting. As a result, plaintiffs allege that they suffered various injuries. For purposes of this hearing, plaintiff Shannon Edwards was reportedly 28 weeks pregnant with twins. Immediately following the accident, an emergency cesarean section was performed. One of the children, Truist, that's T-R-U-E-S-T, Edwards, did not survive and was delivered stillborn. The parties have engaged in private facilitation in 2022 and have reached a proposed settlement. a few other items before I turn it over to Mr. Harrington. On August 8th, 2022, I granted plaintiff's petition to appoint attorney Leslie Braverman as a guardian ad litem for the 6 minor children who are minor heirs under the wrongful death statute. And I have also reviewed and confirmed that Truist Edwards' mother, plaintiff Shannon Edwards, has been appointed personal representative of the estate of Truist Edwards and as conservator of her minor child interest, Lily Edwards. So with that as background, I'd like to turn it over to Mr. Harrington.
Yes, Your Honor. And as a kind of general statement of the settlement, the global settlement is in the amount of $3,250,000, and it is a settlement of all claims that were pending in the Court of Claims, as well as there is a circuit court action for gross negligence brought against the trooper. So this will settle all claims. That case was on appeal at the time of this settlement, and the appropriate appellate documents will be presented, and that will result in orders of dismissals with prejudice across the board. We have also provided Mr. Fedinsky shortly before this hearing with the release language that has the appropriate structured settlement language in there to make sure that the structure gets the benefits that it does, which it grows the tax-free benefits that it gets. And I provided that with him, and he's always been a pleasure to work with, and I'm sure we won't have a problem with getting the release completed. So I know that, also the amended petition was simply, it didn't change the numbers of the settlement, and it just kind of made some adjustments to the structure payouts that has been provided to Mr. Braverman. And I believe he approves of that, but he can advise the court of that when it's his opportunity. Also, as attached as Exhibit C are the waiver and consents from all heirs. It's relatively rare in a case. I was just with Mr. Braverman yesterday in Macomb County placing one on the record, and we weren't able to get all of the waiver and consents. However, in this case, we did. All of the heirs have consented. There is no objection that has been raised to me, and so all of the heirs have waived their opportunity for hearing and consent to the proposed distribution. I do have, I think before we went on the record, I was advised by your court staff that my client, the personal representative, and the father of Truist Edwards were in the waiting room. And I would like to get some just brief testimony from my client, Shannon, at this time.
That's fine. Why don't we bring her from the waiting room and into the virtual courtroom?
Okay, she'll be in here momentarily.
Miss Edwards?
Yes.
All right, Mr. Harrington, why don't you move forward?
Yes, I apologize. Maybe I zoned out. Has she been sworn in?
No, she's not.
Miss Judge, do you do that? Do you want me to do that?
I'll do that.
Okay.
Miss Edwards, could you please raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right.
Hi, Shannon. How are you?
I'm fine. How are you?
I'm well. Would you please introduce yourself to the court?
I'm Shannon Edwards. I'm the mother of Truist Edwards and Lily Edwards.
Okay. You understand that we are here to place a settlement on the record, seek approval from this court to distribute the settlement proceeds. Is that correct?
Yes.
All right. Let me take you back in time. Shortly after this crash, do you remember meeting me at a hospital?
Yes.
And I went over kind of what our firm, the Feiger firm, could offer you as far as legal services.
Yes.
And after our meeting, you, along with your other family members that were in the vehicle, decided to hire our law firm to represent you. Do you remember that?
Yes, I do.
And I gave you a contract for legal representation that I explained to you and went over that there would be certain costs that would be deducted off of the settlement, and our fee would be 1/3.
Yes.
All right. And then after you hired our firm, we engaged in some investigation and ultimately filed a lawsuit on behalf of you and your family.
Yes.
All right. And did you feel that I kept you fairly well informed as to what was going on with depositions and records that we were getting and how the case was proceeding?
Yes, I do.
Okay. We eventually went to a facilitation. Do you recall that?
Yes.
And do you recall that we engaged in settlement discussions?
Yes, I do.
Okay. And at the end of the facilitation, there was a proposal that would provide the estate of Truist Edwards that he would be receiving, well, the estate would be receiving $3,100,000.
Yes.
All right. And your daughter, Lily, would be receiving for her claim $25,000. Is that correct?
Yes.
And let me just step sideways. Lily was the surviving twin of Truist,
Yes.
and she's doing relatively well now.
Yes, she is.
Okay. Meeting her milestones.
Yes.
Okay. And after we received these proposals, which would have been $25,000 for Lily and $3,100,000 for the estate of Truist, did you instruct me to accept that number?
Yes.
Did you feel you had enough time to think about it in the sense of, would it be best to go to trial to get more? Would it be best to, see if we could push for more? Did I give you enough time to consider that?
Yes.
Okay. Nobody forced you into this settlement or coerced you in any way, and you've entered into this settlement of your own free will. Is that correct?
Yes.
Right. And do you believe that settling this case is in the best interest of Lily as well as the estate of Truist?
Yes.
Okay. You were given a copy of the proposed distribution as to who would be receiving what. Is that correct?
Yes.
And you believe that distribution is fair and in the best interest of the estate?
Yeah. Yes, I do.
All right. And on the list of all of the individuals that would be found at paragraph really 14E, Roman numeral 1 through 16, is that include all of the heirs of the estate?
Yes.
All right. Have you been contacted by anybody that has said, hey, Shannon, I'm a member of the estate, I want money, I'm not listed, anything like that?
No.
All right. Has anybody since the filing of these documents said, hey, I don't agree with the numbers that have been listed?
No.
Okay. And you understand that we did send waiver and consent forms out to everybody?
Yes.
All right. And has anybody advised you since the signing of the waiver and consent that they are revoking that or rejecting it in any way?
No.
All right. And are you asking this court to approve this settlement as listed in the amended motion to approve?
Yes.
Okay. You understand that once this, if the court does in fact grant the settlement,
Mr. Harrington, I'm sorry.
No worries.
I had a bad sneeze. I'm sorry. You
I-
understand that once this,
Yes, I saw it coming, so I stopped talking.
okay,
You understand that this settlement is a full and final settlement and will resolve all of the claims that we brought in not only the case pending in the Court of Claims, but also the circuit court case that was up on appeal. You understand that, right?
Yes,
Well, let me say this. You understand that by this settlement, the case is over.
yes,
All right, and that nobody on behalf of the estate can bring a claim ever again. It's done.
yes,
And that after this, we will be dismissing the case, and the state of Michigan will be funding the settlement. You understand that, correct?
yes,
All right. And as we work with the state of Michigan in obtaining a release, do you agree to cooperate in the execution of that document?
yes.
All right. Your Honor, I have no additional questions. I don't know if Mr. Braverman has any, or if Mr. Fedinsky or Mr. DeBear, but I am through, and I would ask the court to approve the distribution as outlined in the petition, amended petition.
All right, thank you, Mr. Fedinsky, Mr. DeBear. Anything with regard to this issue?
No questions from defendants, Your Honor. Thank you.
All right, Mr. Braverman? You're on mute.
Sorry. Other than what I indicated in my report, I have nothing to add. Unless the court has any questions of me.
I don't. We're nearing the conclusion of the hearing, but I don't think, and correct me if I'm wrong, that we need Miss Edwards in the virtual courtroom anymore. Could we have her moved back into the gallery?
I can do that.
Weight room. Thank you. Thank you, Miss Edwards.
No, thank you.
I'll call you after, Shannon.
All right, Mr. Harrington, I did note in both your original and your amended request for improvement of the settlement, you are not seeking pain and suffering or emotional distress. Is that correct?
That's correct, Your Honor. It's just going to be consortium damages.
Thank you. All right, anything further, Mr. Harrington?
No, Your Honor.
All right, anything else from the parties?
Judge, just briefly, for the record, I just wanted to state that I did receive an email from Mr. Harrington 5 minutes before this hearing. There was no attachment to that email. I'm sure after this hearing, we can, as he indicated, work cooperatively on a final release agreement to be separately executed. And that agreement will indicate which departments of government are funding which portions of the settlement and who the payees are for each payment, and other requirements such as registering on Michigan's Sigma system as a payee, which is required for payments that come out of the state of Michigan. But my expectation is that we can resolve that hopefully in the coming weeks, and that the settlement will be, upon execution of that, paid within 30 to 60 days.
All right, very good. Thank you.
Closer to
All right.
30, right, John?
We do endeavor closer to 30, but and certainly by December, I believe, is what the request from the plaintiffs was, and we will work to make that happen.
All right, well, thank you very much. I'm satisfied after hearing from the attorneys as well as from Ms. Edwards that all the interested parties have been notified. They have received the motion to approve settlement proceeds. They have consented to the distribution, and they have waived their right to be heard. That is both what's on the record and also what has been attached to plaintiff's amended motion to approve settlement and distribution of settlement proceeds. Therefore, I am prepared to enter an order to that effect. I did not have a proposed order attached, so I'll have something out shortly approving the proposed settlement and distribution of settlement proceeds. Anything further?
No, Your Honor. Would you like us to send up a proposed order, or how would you like us to do that?
Well, it doesn't seem as though the state really has a dog in this fight. And I'm wondering whether they're going to be very interested to sign off on your proposed order or not. Why don't you send me a proposed order, run it by the defense, and if there's an agreement, I'll likely sign it. If there's not, then I'll take a closer look at it and see if there's any changes that need to be made.
And I'll indicate that it's not a final order, doesn't close the case. And then once the payment's been made, I think I may have already approved John's order of dismissal, Mr. Fedinsky's order of dismissal with prejudice. So if the court is okay with that two-step process, then that'll work.
All right. All right.
Okay.
So unless there's anything else, that concludes the hearings.
Thank you, Your Honor. Take
Thank
care.
you, Judge.
Have a good day.
Thank you.